Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone, to another episode of the Colorado Trial Lawyer Connection podcast. Super excited for this episode for multiple reasons. The first obvious reason is we're here to talk about a $6 million plus verdict on a slip and fall at Kohl's store. So that's obviously number one. Number two, Jessica McBryant's coming back for a repeat appearance, which always makes me happy because that just means that lawyers are out there trying cases and winning and winning and winning. And that is exactly what's occurring with Jessica and Ramos. And I'm excited to have Jared Mazzei. I think I got that right, Mazzei. Maybe I messed it up. I apologize, Jared. My last name's Fuicelli, so hopefully you don't take offense if I mispronounce your last name. Welcome to the show, Jared and Jessica. So excited to have you both here.
Thank you for having us.
All right. So Jared, since you've not been on before, and I don't believe that I've had the privilege of meeting you in person before, tell us a little bit about yourself. How is it you came into the arena of trial work on the plaintiff side?
I pretty much always wanted to be an attorney. My grandfather told me to be a doctor or a lawyer. And then I started watching SVU with my mom, and I just fell in love with trial work. And I had done criminal law in New Jersey and then moved to Colorado and started doing civil law.
Nice. When you were in New Jersey doing criminal work, was that prosecutor, defense work? What kind of criminal work?
So I spent 9 months at the public defender's office. Nice. In the juvenile division. I was working as like a free attorney, basically not getting paid 40 hours a week, and just to gain experience. And then I got a job at a private firm representing all types of gang members in Newark, New Jersey, Essex County. I did some civil work there, but yeah, then I just moved here.
So how many years were you in Jersey doing that kind of criminal work before you came out?
Like 3.5 years.
Okay. And what brought you out to Colorado?
Just something different. My family has lived in the same small town in New Jersey for over 100 years. And
wow,
I was kind of sick of the winters there, the humidity, and wanted something different.
Fantastic. So here you are working at a great firm, getting to handle complex, factually fascinating cases. And I understand that this was sort of your case, and Jessica came on later on to help you try it. Tell us a little bit about the facts of this case.
So our client was shopping at Kohl's, and before she got there, one of the Kohl's employees was taking up decals off the floor from COVID, and they didn't put any caution signs up or anything like that. They were using products similar to Goo Gone, and with those products, you're supposed to wash the floor or whatever surface with soap and water after you're done. They didn't do that. They just kind of wiped it up with a paper towel. Clearly didn't get the whole area. And when our client was turning a corner, she just slipped. The right side of her face hit an end table, and then she fell backwards and hit her head on the tile floor.
Wow. All of it on video, I'm assuming?
Yeah.
How compelling was, it sounds compelling, on a scale of 1 to 10, how compelling was the video to watch?
It was very compelling. It was about 10. I mean, you could see her hit her head and her side of her face, and her feet just go right out from under.
Was there any issue about the types of, because this always seems to come up, any issue about the types of shoes your client was wearing?
No, I don't think it wasn't that big of a deal because, I mean, we're talking about it's inside, so it's not like she was, out in the snow with sandals on. But she had sandals on, but they didn't make a big deal over that.
Any allegation of comparative fault on the part of your client?
No.
Okay. And I also understand from reading about this verdict before that did you get a late admission of liability from Kohl's?
Yes.
All right. Did you guys take a 30B6 deposition of Kohl's, I'm assuming?
No, I just took the deposition of the manager that was on staff and then the employee that was doing the work.
Wow, I love that. Did the manager in that deposition sort of admit liability, or what was sort of up until the point where they formally admitted liability. What was their defense here?
Basically, their defense was she cleaned it, the employee, and she walked over it. So, this doesn't make any sense to me. But like, there's no way they basically said there's no way that she could have known. And I was like, well, that doesn't take care of should have known. Um, and then both the employee and the manager admitted that it's policy to have out caution signs when doing that type of work or any putting any substance on the floor like that.
So I'm imagining in my head that were there like arrows? You said they were cleaning up something with COVID signs. What were the signs that were on the floor that they were cleaning up?
Yeah, like the 6 feet apart. Because this happened near the self checkout area.
Okay. Okay. And how long after the person had removed the sticker did your client fall?
So it was probably about 10 minutes. She had moved back to the next set. So the employee was probably about 10, 15 feet from client. She had moved back a couple times.
Okay. Were there any other patrons that had gone through there without any issues that the defense tried to say, look, it wasn't that bad? Other people were able to traverse the area, or was your client the first person?
She was the first person. She was there pretty early when like they just opened. So
Okay. Yeah, well, it sounds like a very strong liability case. I guess it's not surprising that they did eventually admit liability. So you've got sort of from the plaintiff's perspective, a dream case in that you've got an admitted liability, no comparative damages case against a large store. Talk to us a little bit about your client's injuries, because I understand it's a little different than standard types of injuries that a lot of our listeners encounter on a daily basis.
sure. So she had physical injuries. The way we separated it for the jury was physical injuries and psychological injuries and impairment.
Okay.
For her physical injuries, she suffered a mild traumatic brain injury that from that she developed visual dysfunction, specifically convergence spasms, where she would have trouble with tracking objects that are in her visual field. She also suffered damage to her occipital nerve, so occipital neuralgia, and she was getting stem cell injections for that.
Okay.
We had Dr. Brown who testified as the pain management doctor. He testified that that was a permanent condition. Our neurooptometrist testified that the visual dysfunction was permanent as well.
Okay.
And she had a TMJ injury, which we didn't call that doctor to testify.
How did you, since Jessica comes in this case late, how did you all divide up the medical piece of this for trial? Because I understand it's a 5-day trial. Sounds medically complex. How'd you guys divide up the medical piece?
We were kind of dividing the types of injuries between physical and psychological. I took the bulk of the physical injury, so those experts on that portion of it, and then Jared handled the psychological.
Okay. And what sounds brilliant on your behalf is that sort of owning the quote psychological piece, because it seems like so many times in these concussion, post-concussive syndrome cases, the defense's position is if it's a psychological injury, it's not real. Is that was that your thought process is, look, we're going to divide up these physical injuries and the psychological injuries, but in the end, it doesn't matter whether it's physical or psychological because it all emanates from this concussive injury. Is that kind of how you guys decided to approach it?
Yeah, and the reason we split it up is just because she had three psychological injuries as well. So we wanted to, and all of her symptoms were coming from different injuries. So we wanted to really separate it for the jury so that they can conceptualize it. And we put it in like for opening, we did graph basically of the physical injuries and the symptoms from each one of that, and then also the psychological injuries.
Well, before we jump into the physical injuries, because I do have some specific questions for Jessica on that, talk to us a little bit. You said there were 3 psychological injuries. What were those, and what types of doctors did you have to explain those injuries to the jury?
Sure. So she developed a generalized anxiety disorder that was causing muscle tension. It was causing memory issues. It was pretty wide ranging. She didn't meet all the criteria for post-traumatic stress disorder, so she was given a trauma stress unspecified disorder,
Okay.
basically with hypervigilance and a hyper sympathetic arousal.
Okay.
And then her main injury was the functional neurological symptom disorder, which is pretty rare, but we had multiple doctors diagnose her with that.
All right. So were they psychologists, psychotherapist? What types of doctors were you using to diagnose? And say that for the listeners again, because I want to talk specific. What was the last diagnosis? Functional, because that's a DSM-5 diagnosis, right?
Yeah, functional neurological symptom disorder.
Okay. I apologize if I'm putting you on the spot, but do you know what the diagnostic criteria is for that condition?
Off the top of my head, probably not, but
Okay, I know, but neither do I. We can all go look it up. But you've got sort of the diagnostic criteria. Do you remember which doctor sort of came in and said check, check, check for all that for you guys?
yeah, so first it was within like a week, she was diagnosed, or 10 days, she was diagnosed with it by a neurologist at the hospital.
Wow.
We didn't have that neurologist testify. She had gone to Kaiser, right, Jessica? Yeah, and she was like, we called her and she was pretty rude. So I was like, forget
That's
it.
shocking. I mean, for everyone, our listeners that don't know, and I found this with UC health doctors, they're very reluctant to want to help in any way. But having that record is really useful because then you can have somebody else talk about it. So not surprised to hear about your bad experience with Kaiser, but at least it was in the record. Is that right? So you have a formal
Mhm.
diagnosis from a neurologist at Kaiser, 10 days plus of this, what you're saying is this rare-ish psychological condition. Is that right?
Yes.
Okay. And so what'd you guys decide to do with that at trial?
So we brought it out through, Jessica brought it out through some of the physical doctors, physical injury doctors, and then we had that neurologist had put something out on a message board about people who treat these symptoms, and we got lucky that a physical therapist who specializes in this disorder, she responded, and my client went to treatment with her. So she testified. She was great. Jamie Wahab, and then we had Angela Eastfold also talk about it.
So Dr. Eastfold, she's a neuropsychologist, correct?
Correct.
Now, one of the things that I love that you did, which has worked well for me in the past, is using a physical therapist to cover this and testify about it. And we had just had someone on the podcast not too long ago talking about how when you have like a really good chiropractor, these types of medical professionals that see your clients on a much more regular basis than medical doctors who might see them once or twice a month or whatever can be hugely impactful. Is that what I'm hearing you say happened here? Physical therapist came in and said, I've dealt with this psychological condition. Here's how we treated it. And that landed with the jury?
Yeah. Yeah.
Okay.
I think we got lucky in this case where we had three doctors be experts in kind of the field that she needed at the time. So
Mm-hmm.
we Dr. Randy James, who's a chiropractor, but he specializes in Atlas orthogonal treatment,
Yep.
which is that upper occipital nerve that a
Okay.
lot of chiropractors are afraid to touch, but he has the special tool to do so. Janie Wahab has dedicated 20 years of her physical therapy career in functional neurological disorders. And then Angela Eastfold, who works with brain and behavior, has also specialized in these functional neurological disorders. So we lucked out that that she was able to find two of them and that Angela Eastfold also specialized in it.
I'm so excited hearing about this because your lineup sort of sounds like the A team of medical professionals. Quick question. Did your client have any pre-existing psychological issues that you had to deal with?
She didn't have any, but that didn't stop them from inventing them. So
Okay. How old was your client?
I believe she was 60 when it happened. So she was, yeah, 64 at trial.
Well, what I love to get ahead of myself a little bit because I know the defense team coming consisted of Allison Fall, and having dealt with her many times, she doesn't really have any expertise of any of these sort of unique psychological injuries that you're dealing with. What was Dr. Fall's take on your client's physical injuries before we talk about sort of the psychological, but the physical piece of it? What was her take on that?
Like Dr. Fall in every other case, she said the initial treatment could be reasonable, workup in the ER, maybe some follow up chiropractic, reasonable and related. Everything after that is excessive. She didn't need it. She should have gotten better in a couple weeks. There's no permanent impairment, no physical restrictions. She doesn't need any future treatment.
Hmm. Were you able to talk with the jurors afterwards by chance?
No, unfortunately, they all dipped. They were done. It was the Friday before Memorial Day, so I think they were done.
They did all hug my client or our client,
Wow.
and I've never seen that before in my life. So
Wow. That is amazing. So, Jessica, talk to us a little bit about some of these optical or I forget the right terms, but the convergence disorder, VNG. I don't know if your client had the VNG testing done, but were you able to explain to the jury the objective nature of these tests? And just if our listeners are not familiar with how important eyesight can be in proving a concussive injury, talk to us a little bit about that, if you would.
So that's actually a witness that Jared did. Some of our vision issues were related to TBI, but some of them were also related to the FND. So that one was kind of a mixed bag. So Jared took that one.
Help us understand the interplay with the vision issues here.
well, in our case, the vision issues were actually perpetuating her functional neurological symptom disorder. And so what would happen is she would not be able to track objects in her visual field very well. And that with the startled response, the hypervigilance and the high sympathetic arousal was just kind of like really detrimental to her because it would increase her anxiety very easily when she wasn't able to track certain things around her or things are moving fast around her. So, like, for example, when she goes into the airport, she has to be in a wheelchair and have glasses and basically just like look down because the shiny floor, people are moving incredibly quick near her, and it causes her a lot of difficulties. She can't drive on the highway, same sort of thing, just these
Wow.
objects passing too quickly from her.
Wow, it sounds devastating. And was it Dr. Eastfold that would explain that this is a permanent condition, or did you have somebody else do that?
No, Dr. Eastwold said that the functional disorder was permanent.
Wow. Now I understand the defense, of course, hired their own neuropsychologist. Who was that? Who did the defense use in this case? And I don't know, Jessica, did you handle this, or Jared, was this you?
I
Jared.
did this one, Jennifer Bugwright.
Okay. What were her conclusions?
Initially, her conclusions were that this was all pre-existing anxiety and depression. It had to be long-standing, which was odd. Nothing in her past suggested that. And they also didn't, which we hammered them on, give Bugwright her medical records from pre-incident. So
Wow.
we had disclosed like from 2011 through the date of the incident, medical records, and they didn't give it to her. I don't know why.
Hmm.
But then after we disclosed the 1,700 pages of journal entries, she now said that this was all feigning or faking, basically, and this was all for litigation.
Roses her with a fictitious disorder
Yeah.
mid-trial.
Wow. So, and did she straight up set, so malingering, consciously exaggerating symptoms for financial gain from this crash? She went that far with you guys.
Oh, yeah.
Wow. I mean, I know the answer to this based on your verdict, but gift for you and your client for someone to take such an aggressive stance?
Yeah, she came off, and Jessica pointed this out during the trial. Like, she came off like she had some animosity towards the client. Like,
Weird.
it was like she was taking it so personal. And so, we had videos of the client at her worst in the beginning of her involuntary movements which is a part of the functional disorder. And she would like arch her back and she couldn't walk and her head would wobble. Her legs
Wow.
would, she would walk very oddly. She couldn't walk by herself. And so we had videos of that from her in the hospital. And I played them during her cross just for the effect of putting her on the spot, saying that she's faking those videos because nobody watched those videos and thinks she was faking. I mean,
Wow, what a gift. What was the basis for her to make such a strong accusation?
so she did some testing. She did some neuropsych and some psychological testing. And she came to the conclusion based on that, specifically the validity testing,
Yep.
that the client had been exaggerating and all that. Problem is that the way she described each of what the scores represent are not what the manual says the scores represent. And so what we did was we brought in the MMPI-3, that's the test she gave,
Mm-hmm.
the manual, and we went through all the cutoffs and we made a PowerPoint with Eastfold. So I did it mostly with Eastfold, pointing out all that. But yeah, and they didn't say what she was saying, so the jury just didn't buy it.
So I want to talk about that because I love that. And I want to talk about some of the sort of specifics, procedural aspects of that. My first question is, did you have to fight to obtain access to the neuropsychological raw data yourself?
We never necessarily got the raw data. I believe Eastfold talks about the scores in her
Okay.
report.
Okay.
So we just took it from there and Eastfold gave us what the scores were, and then I just bought the book.
Okay. Got it.
And
So it,
disclosed the raw data to us the night before trial.
Oh yeah, they did do that.
well, because I've had my fair share of neuropsychological experts at trial, so I'm intimately familiar with sort of the scores and the cutoff scores for failing or not these validity measures, and then the embedded validity measures, and then sometimes neuropsychologists create their own validity measures when they're not even designed for that. And I love that you all had Dr. Eastfold be able to come in and explain to the jury what the raw scores were, what they meant, and then I'm assuming that you had her, Dr. Eastfold, walk through the manual and all that information with the jury. Is that right?
Yeah.
And I know the answer to this because we spoke beforehand, but when did Dr. Eastfold do that at trial?
She was the last witness. So
Okay.
true rebuttal.
Gosh, and I'm just so excited inside because in my mind, I mean, what a masterful way you guys tried this case. You get this defense expert on the stand who is straight up calling your client a liar, and then you're able to put up someone who doesn't have personal animosity against your client to actually say, well, look, these are what these scores actually mean. And clearly it worked based upon your verdict. And since we've mentioned it a couple times, I've got the breakdown. I don't want to put you guys on the spot, but you had 1.4 million in non-economic damages awarded, 650,000 in economics, and a whopping 4.875 in physical impairment. Is that right?
What did you say for the economic?
They were all right except for the non-economic. It's a million
Oh,
40, not
Oh, a
1 point.
million 40, not 1.4. Okay. Well, let me
Yeah.
ask you, did you all strategically ask for that amount because of caps?
Yes.
yeah.
How did you do that? How did you inform the jurors that they shouldn't award more than what you were asking for in non-economics?
Jessica came up with a brilliant way to get to that number. So if you want to explain it.
Sure. Since we were being a little fuzzier with impairment, I wanted to do a per diem for
Okay.
non-economic. So I Googled what the average rate a Kohl sales associate makes, and it's about 15.50 per hour. I took the number of hours that she has felt pain, inconvenience, loss of enjoyment of life. And then Jared, in closing, took that number and said her pain, her suffering has been a full time job for her. Instead of enjoying her retirement, her family, her grandchildren, vacations, all that, this has been her full time job to live through this pain. It's going to be a full time job for her in the future. So this is the amount.
Mm. Now, how did you use that amount, if at all, in relation to the impairment award? Because you have a monstrous, almost $5 million impairment award. What was the argument there you used if you tied the non-economic amount to the impairment amount?
So we didn't tie it at all.
Okay.
I had showed the jury before I talked about non-economics, the instruction about what specifically it was. And then we talked about impairment. And so we had the 31% impairment rating from
Okay.
Dr. Brown. And we got this idea from Stephen Padua, the tech guy,
Yep.
to basically put up images of all the things that she couldn't do anymore. And so that's how we talked about impairment. It was everything that she couldn't do.
I love that. And so did you ask for a specific amount for impairment, or did you just leave it to them?
No, I asked for, what was it, 9.8 million.
Okay. So they gave you about half?
Yeah.
Wow. Did you do the whole, if you're saying 31% impairment rating, the whole sort of, this is what a human body unimpaired is worth. And so if we take 31, Jessica's shaking her head no. So you didn't go with that. And whatever you did clearly worked well. So help our listeners give a better idea of how you argued impairment. I mean, you got 31%. You've got all these things that she can no longer do. How'd you go about it?
We basically just let them do the math themselves. But we said that, a big thing was, she can, in the journal entries, they counted up every time she went to Costco or every time she went somewhere. And so, she still went shopping, but it took a long time to get to that point. And they're like, look, this hasn't really affected her life. She can do all these things. And so what we said, because in voir dire, their attorney came out and was like, who likes the Kohl's coupons for 30% off or whatever it is.
Yeah.
So in closing, we said they like discounts. They're getting a discount of 69%. And this is for, the 14 times she went to Costco and the 70 times she went here, her being able to, speak with her grandchildren, not play with them. So all of these things that she could do, that's what they get the discount for. And all we're asking for is the 31%. And we believe that's worth, 9.8 million.
With the 9.8 million, did you attempt to quantify that, or because I'm literally dealing with this right now where I'm trying to strategize whether to attempt to quantify the impairment amount or rather just say that amount is worth 9.8 million or whatever it is. Is that what, did you do that, the latter, where you just said this amount of impairment is worth 9.8 million?
Yep.
Oh, I love that. It's so inspiring. All right, let's talk a little bit about the journal. Did I hear you say 1,700 page journal?
Yeah.
Holy cow. Did you all instruct your client to do that from the get-go, or is this just something that she did?
This is something she did.
She was gifted a journal for Christmas in like 2020 or something. So she had started it before, and then she kept it going every single day afterward.
Okay. Now, what I'm curious about, because I've had that come up before as well, and also voluntarily sort of gave it to the defense. Moving forward in cases where you have post-concussive syndrome, is this something you think you'd instruct your clients to, at the end of the night, Jessica's shaking her head no. So at the end of the night, sit down, talk about your day. Jessica, you were shaking your head vehemently no. Why not?
I think the lack of control over it is scary. There's a lot in there that needed to be redacted. She put attorney-client communications in there.
Okay.
And I think if we are directing it, it's a lot easier to use against us because we could go up there and say, we didn't have her do this. We didn't try to help her fake this rare disorder so that we could come to the jury and ask you all money. We had no idea she was doing this. And when she was asked to turn it over, she was pissed. She was.
Oh.
She wrote about it.
Yeah.
Wow.
The last page said "fuck Kohl's" all over it. So.
Oh my God.
Yeah.
Did that come in or is that redacted?
Right, you can cut that out.
Oh, no. That came in. That came in.
Okay, perfect. Well, I mean, I want to talk more about this because I think it's fascinating. I think our listeners might, their wheels are spinning on this because I've had it in cases where clients have had ongoing migraine headaches, right? So you have post-concussive or cervicogenic. You were talking about the Atlas, people injure upper cervical instability. Seems like a lot of those folks end up with these constant migraine headaches. And I had a client that was rating, I think maybe I told her to do it at the beginning, like every night, I want you to make a note if you have a migraine and how bad it was. And so we were able to use that as this like ongoing data point. I think we might have even created a diagram, a chart, sort of showing that over time. And I do think from that perspective, it helped. But I'm also always leery about kind of what you're saying, Jessica. You lose control. Now, but I guess my thought is, and I don't know the answer, but if a client comes in and we tell them, hey, we want you to, here's a journal, maybe you even create, I've thought about like having our firm create a journal and give it to them to sort of keep track of what's going on. Wouldn't it be work product and then we could decide whether or not we want to disclose it or not? Sorry to kind of spring that question on you, but do either of you have any thoughts on that?
I think if the client is creating it, it's not attorney work product.
Okay. Yeah. Even at our direction though.
Argument that I think a judge would buy that it's not.
Okay.
For pain diaries, journals all the time. So I think it would fall under something that we would probably have to disclose.
Interesting. Yeah. Jared, I don't know. What is your gut?
Rating pain, if it's just like, just rate your pain for your injuries this day, that day, whatever day. But this had her entire life, every single day.
Yeah.
Yeah, I agree
that
with
does
Jessica.
seem a lot different. But I guess, Jared, what about in the typical, let's just say it's even like a whiplash injury or something with a, radiculopathy or I just wonder about it because I have felt like it can be such a powerful piece of evidence. And so I guess my first question is, Jared, in this case, do you think it was a net positive? I mean, it had to have been with your verdict. Is that right?
I don't know. I'd rather have tried the case without it.
Okay.
But their whole defense was based on this journal. We made them look stupid in certain spots based on, them pointing out one thing when the rest of the journal says something else, or, the pain levels ebb and flow and all that.
Yeah.
But, I would have rather not have had it.
Yeah, I love it. One of the things I do love about doing this podcast is getting to talk to, amazing lawyers like both of you that go out and get these great results because it really can be an art and there's so many different ways to do it. And I'm sure that people are kind of thinking through, yeah, I can understand how that could help and how it can hurt. And ultimately here, your client did it without your direction anyway. So you're sort of, left to deal with it one way or the other. It's just fascinating. And I love the pain levels going up or down and people kind of taking things out of context. And was that, you mentioned that Brug Wright, the neuropsychologist, came to the conclusion later that your client was officially malingering. And did you say, and I apologize if you covered this, that it was based upon what your client put in the journals?
Yeah, a fictitious disorder.
Okay. And so the neuropsychologist, did she go into specific examples from the journal that she believed proved your client was lying?
Yeah, she highlighted some sections that she thought was indicative of, the client making it up. Certain things like we was talking about her deposition, and she was like, I hope that the defense attorney, found my situation, sympathetic. Basically just saying, I hope that on a human level, she understood what I was going through. And like, that was evidence that she's making it up. I mean, it was crazy stuff.
From what I remember, the biggest thing she pulled out of the journals was that she would go on a vacation and she talked about how good of a life she had. This was Bug Ray. Just she had an amazing life and she still has a great life and she gets to go on all these trips and do all these great things that other people don't get to do. But she said it in such a condescending way that it just sounded like you just don't like this person.
Wow. Now, was it Jessica or did you cross-examine? Jared, you did the cross-examination of neuropsychologist, right?
Yeah, I actually just threw out what I was going to do with her beforehand and after hearing her testify. And I was like, I'm just going to show her these videos. I'm going to point out that the manual specifically says that you need to use the cutoffs and just like make her look ridiculous. I think at one point I said, "You're the only one that cracked the code in this case, huh?" And she was like, "Yep, that was just me." And I was like, "So it wasn't all of the people with her monitoring her 24 hours a day in the hospital when she stayed 2 nights?"
Wow.
You know, she fooled us. She fooled all of her doctors who she went, over 300 times to. And I was like, "You're the only one that cracked the code. That's what you want the jury to believe." And she was like, "Yep." And I was like, "All right."
Wow. So two things that I love about what you just said is that did I hear you say that you sort of like you had a plan, you had an outline that you were going to use, and then you're like, I'm not going to do it. I'm throwing it aside. I'm just going to go at her. And is that kind
Yeah.
of how it felt?
Yeah.
Yeah. And I love how you all polarized the case and how the defense just like went right at it. It just becomes this stark absolute, you guys are either wrong or you're 100% right, and holy verdict to prove it. I'm curious if you asked the issue about how the neuropsychologist was using these sort of innocuous statements from your client about how, gosh, I sure hope the defense kind of understands what I'm going through. Were you just sort of like, now that could also just mean that she legitimately hopes the defense understands what she's going through, right? Did she fight you on that?
I don't remember what she said when we brought up that point. I think I did raise that point with her, but she was like basically, that she wasn't focused on her injury. She was focused on, sympathy and that sort of thing.
Money.
Okay.
She
Money.
took
Yeah.
it to mean I hope defense heard what I was saying and gives me money for it.
Wow. So, kind of a different off topic question for you, Jared, because this is the first time that you and I have spoken, and your demeanor is so calm and so mellow. How did you not, and you said you're from Jersey. How are you not like jumping down her? How did you keep your emotions in check if you did? Because, you can tell my family's like from New York. So, it's one of the things I constantly struggle with is feeling like I can't show too much emotion or get too angry or anything like that in trial. Have you ever faced those issues? And if so, what's the magic sauce you can tell our listeners?
I actually had an attorney come up to me after one of our colleagues after my closing and was like, you sounded angry. But
Whoa.
she was like, it was good for that case.
Yeah.
So like, I mean, I'm most of the time pretty reserved, but when they were just calling her a liar and everything, and it really, it got to me. But I can be very sarcastic in some
Ah.
of my questioning and like the crack the code thing, and definitely in my closing. But I was pissed. I was really pissed what they were doing.
I mean, it sure sounds like the kind of case where eventually the jurors are giving you permission to be angry, and then they're on your side, as clearly evidenced by Exhibit A jury verdict form. Um, Question: talk to us a little bit about lay witnesses before and after. How did you guys prove that your client wasn't a liar, cheat, and a fraud?
We had her sister, her friend that she also worked with for like 30 years, and then her husband. And I think we had a good mix of them because sister was kind of more standoffish, short answers, really not given much. She made me work a lot to get much from her. But I feel like if every single witness that comes up is super emotional, sometimes they lose a little bit of credibility for them. And of course, defense gets up and goes, you want her to do well in this case and you love her and you'd do anything for her, blah, blah, blah. So I'd get up and redirect and just be like, would you lie under oath for her?
Yeah, off topic a little bit. Did the late admission of liability come in, or were you guys just, it didn't come in? You're just thrilled that they admitted liability.
It came in with an objection every time.
So, talk to us a little bit about that. Did they file a motion in limine on it?
No.
Okay, just an objection, like a relevance objection when it would come up.
We never got the basis for a single objection that was made, but judge
Okay.
them and said that it was not relevant. But we also tried to argue they opened the door to it. They went through her journals, and there was portions in there where she literally would talk about, I hope that I get a fair non-economic award. things like that in the journals. So they try to use that to say, like, yeah, this is one, like, the reason you are bringing this lawsuit. Here's your journal entry. I hired a lawyer 2 days after. Here's your journal entry. I want money. The only reason we're here is so you can get money. So we tried to,
Wow.
you open the door now. How about the
Yeah.
reason she's here is because Kohl's denied liability for 3.5 years.
Did the judge rule against? I mean, that is exactly where my brain was going. Did the judge rule against you on that?
Yeah.
Wow, that is disappointing, I guess is the word that I would use. Disappointing. But I
I
guess
mean,
it
it got
all,
out anyways. So
They
okay.
still heard it like 3 times.
Wow, that is fascinating. And of course, a lot of interest on this case because how long ago did this happen? When did your client fall?
June of 2021.
Wow, that's a long, long time ago. Talk to me a little bit about when you all decided to play the video of the fall. Did you play it in opening, or was there any sort of strategy about when to show the jurors the fall?
We played an opening as many times as we could.
I guess that's the easy answer when you have a very compelling video early, often, and as many times as you can. Did you guys do any focus groups or anything on this case before trial? Jessica, you're
Yep.
shaking your head yes. Talk to us a little bit about what you learned. Well, first of all, what kinds of focus groups did you do, and what'd you learn?
This case was supposed to go to trial back in beginning of March. So we did a focus group right before that. And we had just learned about the videos like a week before that, sent him to defense counsel. So we're 3 weeks before trial and we just get the videos. So we do the focus group completely without the videos, have the group deliberate, see what they say, just in case we have to go to trial and judge agrees that videos are out. And then we play the videos afterwards, ask them.
Let me jump in. Sorry to interrupt you because we might have, and I could be wrong, we might have spoken about the videos before we went live on this. So, and if we covered it, my bad. If not, let's do it again. What videos there were some videos that you all obtained that you disclosed shortly before trial, right?
Yeah, there were videos of her symptoms while she's in the ER with the functional neurological symptom disorder. So the weird symptoms that Jared was kind of showing a little bit earlier, where her head would arch back, she would stop breathing. She had stuttered or stilted speech, so she would kind of take an inhale between each word. Where her friend said she sounded like a robot talking. She had issues walking, she would kind of like pick her foot up and go around to walk. So she had to relearn to walk.
Wow.
Things like that. All of those are on video. Her husband took them while she's in the hospital.
And then, so you get them how far before trial? The first trial?
Like 3 weeks.
All right. You disclose them. Defense freaks out. And is that the reason why the first trial was continued?
Yes.
Wow, that's fascinating. And then I guess, did you guys play any of those videos in opening, or did you save those for trial?
Yeah, we saved them for witnesses.
Okay. And so talk to us a little bit, I guess, about how critical video, both the fall and your client, and any advice you might have for listeners about videotaping your clients in physical therapy or throughout their recovery on how impactful that can be at trial. Because I'm assuming you found it very impactful here.
Yeah, I think it would depend on the injury. I think just like someone just being at physical therapy is, I mean, not that compelling, but when the videos of her like learning to walk again, like, that was compelling. And you could see her symptoms, and it really brought life to something that they were saying is made up.
Mm.
And it's kind of like, they're basically, what I said in closing was, they're telling you not to believe your eyes or your ears. And like it was very compelling. I mean, I would suggest that anybody who has a client with this disorder, they should be filmed
Mm.
because, people aren't necessarily going to get it unless they see it.
It's funny you mentioned that because that's kind of, especially with like a somewhat unusual psychological disorder, it's one thing, this is what the DSM-4 or 5 is, the diagnostic criteria, but it's a whole nother thing to show like this is what it actually means in practice. I mean, that is something I'm definitely taking away from this. That seems brilliant on your part. Talk to us a little bit about your client's testimony. Jared, did you do the direct of your client, or is that Jessica?
I did it.
What was sort of your plan? Like what were your thoughts or your goals of what you wanted to do with your client on the stand? And I'll just sort of confess that I always sort of struggle with the plaintiff on the stand. Do I want to just get them on, get them off? What am I hoping to accomplish? And so I'm curious in a case like this, if what your plan was on what you hoped to do with your client on the stand.
We wanted to have her. So in the beginning of the right after this, she was having post-concussive issues, some vertigo, stuff like that, and really the functional neurological symptoms didn't really come into effect, which this delayed response is perfectly normal for like 10 days. So we wanted to take the jury through those days and, some of her journal entries. We wanted to explain to the jury why she kept a journal. And so try to combat that it was like some nefarious reason. And she had tons of journal entries. So she really was able to express and articulate very well what she was going through and how it has affected her life. So we kept her up there for a decent amount until, I kind of got the nod, like I think that we're good. Um, but yeah, and her husband was great too. I mean, he was extremely emotional. I asked him, what goes through your mind when you hear, defense counsel say that she's faking all this? And he was like, I'm pissed off. And so we just wanted like, and I think this just is in general nowadays, like people want genuineness and like the genuine anger and the genuine whatever it is, just people being real. And he was just so emotional up there. She was very emotional. She started doing some of her movements when she was up there. And then, the defense gets up there and, basically just keeps talking about this lying thing in different ways. But
Yeah, talk to us a little bit more about that because I'm curious as you're telling this whole story. What does the defense do on cross with her?
they basically like pointed out all the times that she went shopping, and they went through every single vacation she's been on since this incident, and all that sort of thing. So, all that 69% that they got the discount for.
They
Wow.
literally counted every single time she went to Walmart, to Costco, to Safeway, and pointed out every single vacation. And then the last one was, and you gave blood 38 times.
Yeah.
Wow. I'm biting my tongue for many reasons on that defense strategy. That is so amazing. I mean, I guess the last question I have is was it fun? It had to have been a blast to try the case together. Talk to us a little bit about working together as a team. What you like when you're trying cases with someone like Jessica. Jared, tell us what was good about trying this case with Jessica.
Yeah, so I've tried a bunch of cases with Jessica. We've been working together for, I don't know, 8 years, something like that. And it's always fun. She is a lot better with objections, the jury instructions, legal arguments. And so I think we balance each other out really well. So I enjoy trying cases with her.
Jessica, what about you? You've tried cases together for going 8 years. That is phenomenal.
Yeah, it's a lot of fun. Jared's probably more cool-headed than I am in most times. He has a lot of really cool ideas. Like this one, we've talked about what the MMPI manual says versus what Bogwright said, but I don't think we could minimize what he did with it. And he had this idea to do this PowerPoint. And so he literally put up on there, okay, in this column, this is what the MMPI says for this score. This is what Bogwright says, and just went through it over and over again. So he has all of those really cool ideas, and he dives into a case more than I've seen most attorneys do. The fact that he purchased the manual, he purchased the DSM-5, and really understood and took the time to really tell the client's story.
I feel like all the listeners are going to be hitting Jared up for demonstrative exhibits because that does sound brilliant. And it always seems like a hard thing to come up with really compelling demonstrative exhibits. Well, thank you both again for coming on. Jessica, you keep coming back. Jared, now that you can come back as many times as you want, because I know that I have learned a lot from this, and I hope that our listeners have too. And just congratulations to you both on an absolutely amazing verdict for your client, who must be thrilled. I mean, to be hugged, I've never had that happen. To have the jurors come up and validate what the defense tried to completely destroy must have just been such a special moment for you both. So Jared, congratulations. Jessica, congratulations. Thank you both. Any last words for our listeners about, these types of psychological cases, mild traumatic brain injuries, taking on big box retailers? Any parting words of wisdom, Jared? Putting you on the spot?
Just that the stuff is real and that we should litigate it accordingly.
I
It's
love
real
it.
stuff.
This stuff is real. I love that. Jessica, what about you?
I would just say get out there and try cases. You look at a case and even you could be like, I don't know. But, if you have a client and you believe the client, then it's worth it every single time, win or lose.
Well, thank you both again for coming on, and thank you everyone for listening. Come back hopefully next week. I think we'll have another one on the Colorado Trial Lawyer Connection podcast, where we are all striving to get better to better represent our clients. Thanks everybody for tuning in. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.